Hey, how's it going, everybody? Welcome back to 2A News Now. And as always, here at 2A News Now, you get your Second Amendment news straightforward and to the point with no BS added in. I had a guy post on one of my videos the other day that he was unsubscribing from my channel because all I do is post bad news about our Second Amendment rights. But unfortunately, every day we have to fight for our Second Amendment rights. And for that guy, here is some good news. A California judge has blocked a new law that would have allowed residents, state and local governments to sue gun manufacturers that manufacture or sell what they call abnormally dangerous guns. So how does one quantify how dangerous a firearm is? Is it the caliber, the rate of fire, some superficial features that make it scary? In the state of California, it didn't matter. They decided to try to open up lawsuits against those who made abnormally dangerous firearms, as opposed to those who make guns that are a regular amount of dangerous. And in a move that surprises absolutely no one, a lawsuit challenging the law was filed. And in another move that shocked no one at all, the judge sided with the National Shooting Sports Foundation. A federal judge on Wednesday blocked California's Attorney General from enforcing a new law that allows residents, the state and local governments to sue members of the firearms industry that manufacture or sell what they call abnormally dangerous firearms. U.S. District Judge Andrew Shopler in San Diego sided with the Firearms Industry Trade Association in finding that part of the gun control measure signed into law by Democratic Governor Gavin Newsom in 2022 was likely unconstitutional. Do you think? It is the first ruling in the case challenging the constitutionality of California's Firearm Industry Responsibility Act. But in a lawsuit filed in May, the National Shooting Sports Foundation argued California's restrictions violated several provisions of the United States Constitution, including the Second Amendment, which protects our right to keep and bear arms. Judge Schlapler is an appointee of Joe Biden, did not address the Second Amendment issue in Wednesday's ruling, and instead found the law likely violated the Constitution's so-called Dormant Commerce Clause, which restricts states from interfering with interstate commerce. The judge said, for example, a Tennessee manufacturer that manufactures guns that are legal in its state, but that meet California's definition of abnormally dangerous, could still face liability under the law, even if its products were shipped to nearby Arizona and used later to commit a crime in California, because the abnormally dangerous firearm rule reaches beyond California's borders and directly regulates out-of-state commerce transactions, and it likely runs afoul of the Dormant Commerce Clause in the Constitution, the judge said. He issued a preliminary injunction barring California Attorney General Rob Bonta from suing National Shooting Sports Foundation members while the lawsuit moves forward. Honestly, it's a very interesting ruling. The judge didn't get into the Second Amendment aspects of the ruling, but it's also interesting to see how this really didn't need the Second Amendment to be unconstitutional. And his reasoning is absolutely correct. It does seek to restrict gun manufacturing and sales beyond the borders of California. It will punish companies for guns that are trafficked into California illegally, which is a matter that is completely beyond their control. And that's a violation of the Commerce Clause. However, the judge should have smacked down the idea of abnormally dangerous weapons even being a thing. For one thing, it's way too vague. I understand why it was written that way, because we Second Amendment type of folk actually enjoy complying with the letter of the law, while blatantly ignoring the spirit of it. But vague laws are incredibly problematic. For example, is a Ruger 1022 abnormally dangerous because it's a semi-automatic firearm? Or is a .50 caliber BMG single shot bolt action rifle abnormally dangerous because it shoots a really big round? Literally no one knows how the term will be applied, which literally means any gun could be potentially declared abnormally dangerous, meaning gun manufacturers would never really know what's acceptable in the state and what will open them up to lawsuits. What I do know is abnormally dangerous is these left-leaning scumbags that are infected with the liberal pathogen, thinking they can infringe on our Second Amendment rights whenever they want to. And that's why we should be grateful to have groups like the National Shooting Sports Foundation, Gun Owners of America, and the Firearms Policy Coalition and others that are out there every single day fighting for our Second Amendment rights. Unfortunately, this is a temporary injunction, and in true fashion, it will be appealed to a higher court And when they do that in California, a lot of the time those rulings are overturned. But there's an old saying, a win is a win no matter how you get it. So this weekend, let's celebrate this win for the state of California. Especially in California, it's an uphill battle. But hopefully in our lifetime, the people of California will be free to exercise their Second Amendment, like a lot of the rest of the United States of America. As always, I would really like to hear your thoughts about today's video in the comment section down below. And if you guys would do me a large favor, if you enjoyed this video and you want to help the channel out and help it to continue to grow, please just take a few seconds of your time to like, share, and subscribe and hit those post notifications. I would be very grateful. And I invite you to come back and watch my next video.